Welcome to the Scalable Real Estate Investing Podcast, where we discuss the most scalable strategies, tools, and approaches to successfully invest in real estate. Learn how to make the most impact of your time, automate your real estate investing business, find off-market deals with minimum time invested, and leverage your capital to create as many income streams as possible so that you can achieve true financial independence. Thank you for tuning in. I'm your host, Mason Clement. Hi everyone, Mason Clement here. Before we get into today's episode, I wanted to ask you one question. Are you sick of the wild swings in the stock market and ready to try something different? Did you know that investing in stocks actually put you at the very bottom of a company's capital structure, meaning that there's practically 0% chance that you're going to get any of your money back in the event that the company files bankruptcy? That basically you're putting yourself in the riskiest position for a questionable return. Personally, I hate the unpredictability and just waking up and having half of my investment gone when I didn't do anything wrong. So what a lot of people don't know is that you can actually make higher returns on a consistent basis by investing in the opposite end of the capital structure, which is actually the safest place to be, which is on the debt side in a first lien position. And you can do that by investing in real estate, and specifically investing with my company in notes that are backed by the land that we purchase. So if you're ready to diversify your income stream, go ahead and go over to scalablerei.com and click on invest in the top right corner. There you're going to find a form that you can fill out to determine if you're eligible to invest with my company, Celion Capital, and we'll be reaching out to you to schedule an introductory call and speak more from there. So thanks a lot, and let's jump into the episode. Hi, Scalable Investors. Thanks for tuning in to another episode of Scalable Real Estate Investing. I'm your host, Mason Clement, and today we have Toby Mathis, who is a tax attorney, founding partner of Anderson Advisors, and also a real estate investor. So we're going to unpack a lot of stuff today. I think it's going to be really interesting and actually applies to kind of what I'm doing in my business. So we'll try to fold all that in together. But first, if you're not familiar with Toby, what we're going to do is just jump into his background. So Toby, how are you doing?
I'm doing awesome. Thanks for having me, Mason. This should be fun.
Yeah, definitely. So like I just said, why don't we just jump into your background? Like, what was your journey and what brought you to co-founding Anderson Advisors and doing real estate?
I can make it really simple. I didn't really like lawyers, and I grew up with a mentor who ran a business where he dealt with lots of lawyers, and he asked his son and I to go to law school so that he didn't have to deal with third-party lawyers. It's kind of fun. Traditional business. So I got into the law, not because I wanted to be Matlock and go to court and do all that, but because I wanted to know how it worked with regards to business so that we could make really good decisions on the business front.
Okay. And also, I forgot to mention a second ago that you're also the author of Infinite Investing. And so you talk a lot about the different ways to invest. I felt like it was kind of like the next a level up from Rich Dad Poor Dad type of financial education stuff. So, but how did you get into the real estate side and like that whole approach to investing?
All right. So this is a bit of a story, but bear with me just for a second. So I wrote in Infinity Investing as a culmination after about 20 some years of doing tax returns for affluent investors. So I got to see what worked and what didn't. So there's lots of gurus out there that tell you, here's what you do and here's how you make money. But when you're the guy who does their returns and then compares what they're saying with what the results are, they oftentimes are two different things. So I ended up doing Infinity Investing based off of a client. She had been on Oprah and Steve Harvey, and she'd actually been on one of NBC's Secret Millionaire series. And she said, hey, Toby, come talk to my group. It was about 2000 on financial stewardship. And she said, you have more background in this than you realize. Please come in and just talk about what you've learned from all your clients. And I went out there and I talked about just basic calculations on returns and how if they were working with a non-fiduciary, chances are they weren't making the return that they were seeing. I was using mutual funds as an example, which have about an average expense of around 4.8, but the published expense is going to be less than 2%. So people don't realize how expensive they are. And boy, I got hate mail. I got all this anger out of these folks. And I was kind of shocked, but I realized then I was directly over target. And so I just kept digging into it. The more feedback I got from people who were very angry, which was mostly financial folks, people that sell insurance products and things like that, They didn't necessarily want anybody explaining how much that was really costing, because, when they say, hey, you made 7%, but it cost you 5, you actually netted 2. I mean, that seems pretty regular, but they're always telling you made the 7. And even my mom's fallen for this. And you start actually looking at the actual return on your money, and it's really low. So that's how I got speaking about it. My introduction into real estate, though, occurred in about 1988, 1989. And my mentor, again, a really great guy, who I worked with in my formative years, and actually his son and I both practice law. I'm not a traditional lawyer. I do business, but his son carries on and acts like the traditional lawyer. The dad even went to law school, but got thrown out because he had really strong opinions about things, kept telling the professors they were idiots. So he got disinvited to law school. But long story short is he introduced me to a friend that invested in real estate. And the guy's name was Boyd. He was in Burien, Washington. Somebody could probably find him. But he was a Harvard grad, super smart. And he had this, if you remember the dot matrix printers where they had the little tear off edges, he had pages and pages of properties on this paper that I was looking at. And it was like he would print out all the properties he owned in Seattle and in Denver. And I was just like in awe of all this property. And my young brain could only think of how much it was worth. About 10, 15 years later, it clicked, something else clicked, which was he owned a whole bunch of cash flow machines. Like he owned all these properties. Who cares what they're worth? What we care about is what they're generating. And I'll use the Monopoly example. You play Monopoly. You don't win Monopoly going around the board and trying to stay out of jail and collecting $200 every time you pass go. You win Monopoly by buying properties, developing that property to maximize it, and then you trade your properties up to hotels, right? Maybe it's apartments, but you're going from single family to multifamily, but you're creating things that generate you cash flow. And my experience with Boyd, even though it didn't sink in to more than a decade later, made me realize that's what the really wealthy guys are all doing. And I looked at the returns of my affluent investors, and we do about 10,000 tax returns a year, just to give you an idea. So it's not like I have 100 clients. I'm like, here's the 3 that are really successful. No, we have tens of thousands of data points that we can look at, if not hundreds of thousands over the years. And I can tell you the people that are most successful own cash machines in the form of investments. And what I mean by cash machines are cash flow real estate, cash flow assets that produce income that don't require the work of the owner. You own it, it creates money. And that way, for hundreds of years, I could own that. Infinity investing means I own it for an infinite period of time. I'm not getting rid of it. I can pass it on to my kids. I can pass it on to the organizations I care about. And I'm not passing a burden onto them. I'm not giving them a business that they have to decide if they're going to work in, right? I'm giving them an asset that's going to continue to create wealth for hundreds of years. And that's what the most successful people do. That's what they create. And that's what we should all be aspiring to do.
Okay. Yeah. And a lot of the next few questions that I'll be asking are related to things I learned on your YouTube channel, which I found really helpful. I'll put a link to that in the show notes. But on one of the episodes you had mentioned, or videos, you mentioned that you own like hundreds of properties. So are you mainly owning single family rental properties? Or are you doing multifamily, or what are you doing?
Yes. No, I own it all. So
Okay.
we own commercial buildings. We own a few hundred single families. We own apartments. We own some 8plexes, 10plex, 12plex, 4plex. We like real estate, period. We own a bunch of manufactured homes. We own the mobile home park where we own the pads only, and we sell the units off them. We own some storage that we like. We do own an apartment complex, but I'm not an apartment guy. There's people that are way better at that than me. What I do like is just cash flow assets. So I tend to go after things that are no-brainers, that have great markets for them. So if I want to get out, I still come out ahead. And And yeah, I don't know how attorneys and accountants advise their clients if they don't do what their clients do. So there's so many nuances in real estate investing, for example. I don't know how you learn them without doing it. So, I'm one of those old school guys where I remember when Nike came out and they said, just do it. And I was like, yeah, just do it. So if a client's doing retail, you better learn retail. Just do it. Open something up, learn it. That's the best way to learn to do something, is to do it. And so we took that to heart. And of course, real estate's a great investment. Oh boy. Yeah. I mean, we have a lot of cash machines, so to speak, and we encourage other people to do it as well. And we're not a big leverage. Like I don't like I don't like personal debt at all. On investments, I like a little bit, but we did it all without having to rob Peter to pay Paul. We didn't have to go to the banks and do crazy leverage. There's deals out there. You can even do subject twos to a certain extent. If you do need the loan, it's better to have the guy that owned it before you. Or if there's already debt on the property, it's better to take it over, especially nowadays with the interest rates going up. This is a great market for things like that. But otherwise, I tend to be like, hey, you know what? Anybody could retire. You're 6 properties away, 6 good cash flow properties away that you own outright. You never have to work again. They'll have enough money coming in month after month that you'll never have to worry about, where, a roof over your head and food. And then you can get really to work, because now you're a volunteer and you're not, that stress is gone, and you can have a lot of fun in the field of real estate.
Okay. And when you say we, is it like an investment arm of Anderson Advisors, or you and some just separate folks?
My partner and I have invested in almost everything together. So Clint Coons and I started Anderson. Michael Bowman's also a partner there. We had a lot of fun growing it over the years, but Clint and I were the ones that like invested together. So we would always buy things together. We had this thing in our head of, let's buy a property a year. And then that became kind of too easy. So you're like, let's buy one a month. And then it was, let's buy a property every week, and you kind of let's just see what deals come in and we'll just get them. So you get that bug of buying real estate. And, and there's folks out there, I'm going to be like, I know who you are. You're addicted to buying real estate, aren't you? Right? Yeah. It's kind of it's addictive. You like to buy the assets. You like deals. You like being in the middle of it. It's fun to close on. And you're never too worried about any particular deal. You just, law of averages work their way out when you use the correct assumptions.
Okay. Yeah, that makes a lot of sense. I had the same experience when I started first buying my rental houses a few years ago in 2019. And then I got kind of burnt out because they weren't cash flowing a lot, because I didn't really know what I was doing. Now I've come a long way since then, but I know what you mean in terms of getting that bug and getting addicted, just doing as many as possible.
Well, Mason, you're doing you're doing something, you're developing properties too, right? You're buying a lot of land and you're putting that know-how. You're not going to learn that out of a book. I'm sorry. There's lots of folks that'll say, oh, teacher development. You got to get your hands dirty, and you're just using safety rails, and you're using proper mentorship to make sure you don't get too crushed when you make a mistake, because you're going to make a mistake. Same way when you're learning to walk, you're going to fall on your butt a few times. And the trick is having people around you that'll keep you from, falling down the stairs or really hurting yourself. So I'm sure you did the exact same thing, and you're going to end up with spectacular results because of it. And every day your skill set gets that much stronger. And skills, I'm sorry if anybody ever says, you got to own the asset. Your skills are an asset. So your education is a huge asset, and your experience is a huge asset. And if you don't have it for yourself, borrow it from somebody else. Find somebody who does have that experience.
Yeah, exactly. Yeah, I've invested definitely thousands of dollars, tens of thousands of dollars in various different mentors. And I've started to experience, if all of them are focusing on the same niche, like land investing, for example, like I focused on, eventually there's a law of diminishing returns where my learning curve is plateaued. I'm like, yeah, right, I got it. And I need to start my own mentor program now, to be honest. But
you do.
But yeah, but back to your point, I mean, thinking about it, comparing it to like paying for the college education, I'm not saying my college education was worthless, but I've definitely learned how to make a lot more money in a lot shorter amount of time by paying those mentors. And so it's been extremely valuable.
And you can have multiple mentors. That's the thing, is everybody's like, what program do you like the best? I'm like, there's a lot of them. What I like is the philosophy, and there's nothing that says, hey, I got to learn single family, or hey, the way to make money is in tax liens, or hey, it's in flipping properties. The answer is yes, they're skill sets and they layer upon themselves and they make you better. And you never know when you're going to pick up something in a land development course that's going to help you as a single family purchaser. It doesn't hurt you to continue to educate yourself. And there's no such thing as what's the best strategy. It's the what works for you, what really speaks to you, what's in your personality, what can you sleep with at night, what levels of risk, or what kind of investing do you fully understand to where you don't sweat it. That's, and I always say to people, it's like, look, just find what is speaking to you. I can't do that for you. You'll know when you're getting over it, the same way as it's like finding a spouse or something like that, or somebody that you really care about. Even, your dog or your cat, whatever. It's when you see them, right? And they're like, oh my gosh, this is the great, oh, this is the cutest one, right? Whatever. And it's no different in investing. You just sit there and you try to find that thing that fits with your personality. There's no rule to it, and there's nothing against learning lots of different skill sets. It's still a great asset.
Yeah, definitely. And I don't mean to say I know everything about land. There's definitely always more things to learn, and probably could find another mentor that's teaching a very specific offshoot that I didn't consider previously. And there's always things to learn.
But the mentors have mentors. Everybody does. And that's the thing, is that we should be just saying to ourselves, hey, you know what? I learned something every day. I don't learn it from doing the exact same thing every day. I better push myself outside my comfort zone. So, they call it in the practice of law, they call it practice for a reason, right? Because it's not like I know everything about this. Whenever you hear somebody who says, I know it backwards and forwards, I tend to get a little nervous. And I think I'm dealing with somebody who might be slightly sociopathic, because most of the really successful people out there that I've met are very humble, and they're also willing to share what they've learned. They're going to make you work for it, though, right? They tend to be pretty jealous of their time, but willing to give it away, so long as you honor that time and show that you're not just taking it for granted, because nobody's going to do it for you. So I've worked with so many really cool people over the years, and I've learned so much from others. I always just look at it and say, as long as you're open and you're willing to give too, it'll flow to you.
Yeah, definitely makes sense. We'll jump into the meat of things. I was watching over the weekend some of your videos. I'm almost like using land trust, and a lot of people hear land trust and investing, and some people use it, some people don't really know about it, or it's kind of this still a black box. And also, from my experience, some people will teach you how to use trust, but they don't necessarily do it the right way. The way that you've taught in your video on YouTube was actually, it's like, oh, that's the way I should have been doing it. Because I was having my brother be the trustee and all this kind of a mess. I created an administrative nightmare, to be honest. I was doing a new trust for each property and all this. We'll get into all that in a second, but why don't we just start at the beginning? How does a land trust differ from other trusts, and specifically like with the revocable trust?
Yeah, so the easiest way to think about trust is there's always going to be three parties. There's the party that puts the asset into the trust. There's the party that manages it, called a trustor, or a trustee, excuse me. And then there's the beneficiaries. And so you always have kind of those three main parties in any trust. It's either revocable or irrevocable. If it's irrevocable, then you get into another world of complexity. In other words, you can't change it. The grantor creates it and they have no control over it. That's not what we're doing here. This is your standard run-of-the-mill grantor trust, where the grantor retains the rights to change it, revoke it, do whatever they want with it. What this really is, we call it a land trust, because there's very few states with land trust statutes. It's almost all just contract law. It's all common law in different states. No different than a living trust. And I want to just make sure I emphasize that point. A land trust really is no different than a living trust. Its sole purpose in life is to hold real estate, hold land. So we call it a land trust, but it's really just a grantor trust, revocable instrument that you can change. But what it does is it puts a different name on title for a property. And you got to ask yourself, why would I not want my name on a property? Well, maybe because there's billboard lawyers all over the place looking for rich people so that they can sue to take a piece. They're looking for the insurance. They're looking to scare you. They're looking to see whether or not you become kind of the honey hole, where they can go in and they're like, this person has lots of assets that I can take. Mark Cuban is pretty famous for saying, what's the worst part about getting rich? And he was like, all the lawyers, right? When you have wealth, people try to take it. It's just part of life. Government's going to want a piece. Your tenants might not like the fact that, like, if they know you have 10 properties and they get a beef with you, when you try to evict somebody, expect that they're going to come back around and they're going to say, I had mold, or I had discrimination, or you looked at me funny once, whatever, and they're going to try to take a piece out of you. And so one of the things that we've learned over the years, talk about doing, right? One of the things you learn is there's something called security through obscurity, that if people don't know what you have, you tend not to get sued. In a land trust, I could have anonymous ownership of real estate. I don't care what state you're in. Everybody in Arizona, you can sit down, you can actually do this. Well, but you have to list this. Ask who has the right to force a listing of a beneficiary in Arizona. It's actually the beneficiary, right? So why are you going to enforce it against yourself, right? There's lots of things out there that there's bad information, and we see it on the land trust front. We're like, this is a great vehicle. It's not a true asset protection vehicle, except in couple states, but like Florida has asset protection components of their land trust statute, but most states don't. Everywhere else pretty much no. So they're not an asset protection tool by themselves, but they play really well with LLCs. So for example, I could have a property in a land trust and I could assign the beneficial interest to an LLC. So on title, it's a land trust. So when you look at the public record, it says ABC Trust by its trustee, 123 LLC, a Wyoming LLC. You can't even see who the owner is, right? There's no name associated with it. And then you say, well, there's no asset protection there. Well, we have the beneficial interest sitting in an LLC. Well, where's that listed? In your document. If you get sued, that's what you're going to put out there. Hey, thanks for suing the land trust. Here's its beneficiary, this LLC. Property is in the LLC from a legal standpoint. So they're going to go after the trustee, which is also an LLC, right? Well, where's the asset protection in that? It's complete. It's the same thing as it being in an LLC. The difference is I could have 10 properties and nobody knows which LLCs they're pointed to. So it's not that situation where you see, hey, this party here has a whole bunch of property. They have a whole bunch of real estate. And so, here comes one of their tenants. They say, I think I got sick in one of the properties. That landlord's just mean. And, and I think there was mold. And they go, let's see what this person has. Oh, they have 20 other properties in that area. It's an LLC that owns all these properties, or they can see it's the same member because they're listed in the Secretary of State and they don't know how to obscure that. And so they could see this, and the lawyer says, bingo, that's somebody that has some deep pockets. And if nothing else, they're not going to want to have to deal with 2 or 3 years of litigation. The lawyer usually does it on a contingency when they're representing a plaintiff. So let's say they had I'll give you real life, just because sometimes people are like, this doesn't really happen. Yeah, I'll give you real life. So I had a client, they weren't our client. They became our client after this, but they had their dream house in Colorado Springs. And they said, hey, we're going to rent it until we're able to move there. They lived in California, and they rented it to a nice family. Within the first week, that family had flooded the downstairs. There was a basement area that was converted into a bedroom, and somebody had left and clogged up the shower, and they left it on. So we think their kids probably, were having some fun and made a mess. And instead of calling up the landlord and saying, hey, we flooded your downstairs, they called up University of Denver professor, somebody to come out there and do air quality samplings a week later. We think there's mold. They tore up the carpeting and removed it from the unit so that they could see the watermarks. And they claimed that they were sickened and that they made an insurance claim. And they said that all the furniture was destroyed in the place. And you're looking at it going, but they caused it. Doesn't matter. They sued. 2 years later, the case finally was resolved in the courthouse. It cost the client over $250,000 out of pocket to defend that. And they end up prevailing, but there's no way to get their money back. The individual that was trying to shake them down, which is what that was, it was clearly they destroyed a piece of property. And instead of just saying, hey, here's $5,000 to fix the carpeting and to fix the downstairs, I'm so sorry. Instead, they just, they got in a lawyer and they went aggressive, thinking that maybe they could get some more money. Just a really bad situation. The lawyer was willing to take it on because there was always that chance that, there was always kind of an offer on the table of about 50 grand during that whole time. And they just wouldn't take it. They kept thinking that if they got to that jury, there was a good chance that they were going to win and take from these individuals. And you just look at that. And the reason that they were doing it, and this God's honest truth, was because they did a search on them and they saw the properties that they owned in California. So they owned it in their individual names and they did a nationwide search to see what other properties they had. And they said, you live in this particular area of California, you obviously have money. And you're going to have to litigate here in Colorado. You're going to have a lawyer here in Colorado. It's going to be prohibitively expensive. We want X. And it was just an unreasonable amount. Now they won at trial, but the question is, did they really win? They're out of pocket $250,000 plus countless hours, sleepless nights, and all that. Could have been avoided had they never seen that it was an individual that owned that property. They couldn't tie it to an individual, and they had no idea what that individual owned because that individual maintained strict compliance with keeping their properties out of their name, so you couldn't see it. If that had been the case, the lawsuit never would have happened. And we see that over and over again. I mean, I could give you examples all day, some pretty extreme ones, but at the end of the day, this is what it is. If people can't see what you own, they don't try to take it. The second they know what you own, most people won't try to take it, but there's folks out there will get themselves a lawyer and take a shot at winning the lottery with you.
That's interesting and really scary. And that's honestly why I started using trust initially, like my first year of operations. But the reason I wanted to get into it is because I primarily was doing, and I'm still doing, a lot of just flips and wholesaling. And the hold period is maybe 3 to 6 months. And so as I spoke with my CPA and my other attorneys, maybe they just didn't really understand it because they're not real estate investors themselves. They were like, well, why are you doing all that? That's just kind of creating some cluster mess. And, it's silly. You should just get some, business insurance policy to cover stuff and just do everything in your LLC and all this. But what is your perspective? Like if someone's just wholesaling and flipping, let's say, again, just like land where you don't even have tenants or anything per se.
Yeah, you still have chain of title. So if something bad happens on the property, we've seen folks get drawn into litigation 12 years after they sold something with the allegation that, chain of title doesn't go away. So like once you're in there, you're there. And there's a good chance you're going to get wrapped on if there's an environmental claim or if somebody says there was a defect that was known and you knew or should have known and you didn't disclose it. They're going to sue everybody in chain of title. So like whoever that is doesn't have a lot of experience in real estate because that stuff happens fairly consistently. But more so is your liability is with you if you're the one who's flipping a property. You can get insurance all you want, but the insurance is not there as your buddy. The insurance is there to cover you so long as you comply with that policy. And then there's exceptions to the policy. And so you have to make sure you don't fall under one of those exceptions. And so what we see far too often is policies that don't cover because they fall under a technical exception. For example, the mold case I talked about, they had an individual and umbrella, and it was under the exception for toxic mold. So they didn't have coverage. So they didn't have it. Well, there's probably some lawyer out there who told them the same thing. You only need good insurance. Sorry, I can give you a claim right now. It's still going on. I don't want to give too many of the facts, but multi-million dollar claim. It was a commercial property with valet. Valet ran over some patrons, caused some severe bodily harm to two people. And guess what was in the policy? If you used a third-party valet service, it's an exclusion. So the two owners were two relatives, and one of them was our client, and the other one wasn't. The one that was our client settled immediately for a really small amount, less than $25,000, I think was the total amount. The other one is still in the litigation. It's been going on over 5 years. So I can say, aha, here's the two pieces of advice. This one over here says obscure. This one over here says don't rely on insurance. And it's probably going to cost the guy just about everything he owns. And so I always just kind of look at it and say, hey, what's the worst thing that could happen and how do I mitigate it? So if I'm flipping a house, let's just say that there was an allegation that, let's say that a deck collapsed and it caused significant harm to 10 people, young people, severe bodily harm, and they come after you because you were the one that was in control of the flip and your contractors put it up and you're ultimately responsible. What I'm going to say is if you did that individually, or if you did that through one entity, the liability is going to wipe out whatever that is. It's either going to wipe you out or it's going to wipe out that entity. And if that entity is continuing to flip, obviously that's going to be a problem because that's your living. So what you do is use LLCs per property. It's a few $100. I know it's pain. And, they don't understand it. So it's a cluster, right? They immediately, I could have subsidiaries. I could have disregarded LLCs for tax purposes that make no difference and flow up to the parent organization. But title is taken in that LLC and I dissolve it when the deal is done. There goes my liability. They ever have a claim, it's against a dissolved entity. Bye-bye. No, there's no, it's done. It freezes it in its track. And how much is that worth to me? Not having to worry, but like looking over my shoulder, worrying that something I did at some point is going to come back and haunt me. That's worth a lot. And it's that peace of mind that we're shooting for. We want to be able to go out and invest without fear of somebody taking it from us. And we don't want that nuclear lawsuit. Again, these guys drive me crazy. I could give you examples all day, but I'll tell you one that really, really bugged me. Was a gal, she had 15 pieces of property. She was told again, the insurance was the way to go, which I don't say don't have insurance. I say couple it with an LLC. And this was back in the 90s. LLCs were not universally recognized the same way people say they don't know what a land trust is now. But LLCs were not used for commercial properties back then. It wasn't a requirement to close. Now we look at it going, what are you, bonkers? But back then, and she had good lawyers, good accountants. They said, get good insurance. She hired window washers, and it wasn't even her, it was her managers. 2 window washers go to clean a commercial building that was 3 stories. They hit an electric wire. The guy on top electrocutes himself. The guy on the bottom sees his buddy doing the shake on the ladder. It was an aluminum ladder. Goes to climb the ladder, never leaves the ground. As soon as he made contact with the aluminum ladder, killed him. So you had 2 young wrongful deaths. And what do you think the insurance did? They denied the claim because even though these 2 young men had represented that they were licensed and bonded, they were in a revoked status because they hadn't paid their appropriate fees. So they said it was not covered underneath the policy. What did it cost her? 15 pieces of property. She said it was like dominoes. And the thing is this gal was, when I met her, she was in her 80s. So this must have been right in her late 70s. And her comment to me, because I said, why, she was an older person at an asset protection class. And I said, what are you doing here? And she says, I'm going to make sure that if I rebuild it, that they can't do what they just did to me. She even lost her personal residence because everybody says, oh, they don't take your personal home. Yeah, you have a homestead exclusion. It's usually really small. So she was in I forget what state it was up on the East Coast, but it was a tiny homestead exclusion. So they foreclosed on her house and she got the little bit of equity. Like in some states, it's 40, 50,000. Sometimes it's less. So it's just, you hear these people act like they're omnipotent. Oh, you just need this. What you have to be asking is, what's the worst thing that could happen? And is there a solution to keep that from wiping me out? If so, how much? So insurance is great. I'd say get umbrella insurance. And I would say get a commercial umbrella policy so it covers your business and you. right? Don't just get a personal because it's not going to cover your business necessarily. But I say get that, but also make sure that you're putting a box around your investing so they can't take your stuff. Keep it so that this is the worst case scenario. I've got 5 properties. I have 2 LLCs, 3 are in one, 2 is in another, right? Worst case scenario, I lose the 3 properties, right? That's you can do that. Like I'd probably say if you have 5 properties, put each one in an LLC. I'm going to say it's not worth that risk. But again, it's your determination. It's not somebody else's. I'm not going to put my wallet in your pocket and say, think like me. I'm going to say, based off this information, what are you comfortable with? And then let that client make that decision.
Okay. Yeah, it's also why I had set up a series LLC, because the idea is that each series you can isolate the liability. But what I found as I worked with that entity is that there's just not a lot of case law, and there's a lot of obscurity, and people don't even know how things are handled. It's like, yeah, maybe in Texas where the series LLC is registered and created, like maybe liability is isolated there under that state law. But what if it's outside of that state? And it's a whole mess. So it almost seems like it's cleaner just to have a separate LLC, brand new LLC.
You can do both. So if you're in a state like Texas where you have a series LLC statute, I think there's 14 states right now. You're good in that particular jurisdiction, but in other states, it doesn't have to look at it and say, oh, that's a series. It's recognized under Texas law, but you go to California. California may say, nope, that's one organization. So you don't use a Texas series LLC in California. That's all that means. And that's kind of like a no-brainer, right? You're like, hey, why would I do that? But there's still people that do it. And you're like
buy a California property, put it into the series underneath my Texas series LLC.
Yeah, I wouldn't do that, right? I wouldn't do that. I would do something that California is going to recognize. Now they do have, the Constitution, full faith and credit. We have to recognize somebody else's laws, right? But that's also against the rights, the fundamental rights of that state. So that state could say, hey, we're not going to recognize the Texas because the rights of our people here in California outweigh the right of that individual in Texas to have their LLC recognized under state law. It's happened here in California. We're going to apply California law, which does not recognize those series, right? They're going to say, unless you register it in the state, which it doesn't recognize a series. So you're going to have to file each series as a separate LLC in the state of California, which is probably what they do. They're not going to recognize it, which that could be cost prohibitive because you're going to have franchise tax in each one of those series, which is what California said they are going to do to Texas LLCs anyway, or wherever, any series. They're going to say, we're going to treat that as a separate LLC and require it to be compliant. If you want to do California, I would encourage you to maybe take a gander to my partner, Clint Coons, and listen to his channel, because you use a Wyoming statutory trust and you register each statutory trust, each sub-trust into California because they treat it as a business trust and it's not subject to the franchise tax, but it still has the same protections as an LLC. So if you want to have the asset protection without having the issue of the franchise tax, there is a workaround. There's always that stuff that's floating around out there. You just have to talk to people that do it.
Okay. But back to the original video, and I could post a link to that video in the show notes I'm referring to. You talk about using a Wyoming LLC because of the anonymity for the trustee, but then for the beneficiary using a separate second LLC. And is that also a Wyoming LLC?
Yeah, it's probably in the state. So remember, you want whatever state court I'm in is going to have to recognize what I'm using. So if I use a land trust in the state of California, technically I could have an out-of-state LLC owning it. But if it's going to defend itself, it's going to register in the state of where that action is taking place. And if you did it, now all of a sudden you have that nasty $800 a year. Plus there's a surcharge. If you make too much money in an LLC, it's up to I think the tax is about $11,000 a year, depending on how much you make. It's a big surcharge. So we tend not to like LLCs. So again, we would probably use a Wyoming statutory trust. You're probably registering it there, so you're not hit with that extra. And Or if you were in a different state, let's say you were in Texas, where your LLCs are pretty strong. California doesn't have great protections for their LLCs, so we don't particularly care for them. But let's say Texas. Texas has a great statute. So maybe you have a land trust in Texas, which these, once you set one up, you could just do them yourself. They're really, really inexpensive, probably the cheapest entity you could do. But you have that land trust sitting there, and its beneficial interest is being held in a Texas LLC. So for inside liability, so if you have real estate, something, that property burns down and hurts somebody or collapses and kills somebody, right? It's limited to that property. If you have the insurance, you have the equity in that property, but they can't cross over into your personal realm and try to take everything else you own. You're limiting your liability. Just put a little box around it in the state of Texas. Now, if somebody tries to sue you and say, hey, I want Mason's assets, I'm going to, like, let's say you had you had one of your kids gets into a car accident. And this is a real story, actually. Something like somebody ends up, the child kills somebody in a sidewalk. I'm sorry but this is actually has happened to one of our clients, and they go after all the assets. And if they're in your name, like again, Texas LLC, they can take that asset. They can actually foreclose on that asset. If it's in a Wyoming LLC, they cannot. So not only are they not going to be able to see it, it's going to be anonymous. But even if they do, the most you can get against a Wyoming LLC is something called a charging order, which is essentially a lien to get against that LLC. Now, are there Supreme Court cases on this? No, because nobody has ever taken it that far, because the statute's very, very clear. What it does is it puts you in a situation where you're not going to get shook down. And if somebody is coming after you, they can no longer take your those items at their will. That's going to force a settlement. All of a sudden, they're dealing with somebody who has a structure. If it's so bad that they're actually doing supplemental proceedings, they have a judgment against you, and they're coming after your assets. It just means that they can't just sell all your stuff off and take it. What it means is they're going to negotiate with you as a result, and so you can settle these things out. Generally speaking, way before there's ever litigation that goes to trial, you're going to end up settling these types of things, because they're going to look at it. They're going to realize there's nothing for them to take, and lawyers don't want to work for free. Most of the time, if they're a plaintiff's lawyer, they're working on a contingency, and they have a fiduciary duty to their client to get them the best result without subjecting them to adverse events. The last thing they want is to say, hey, let's spend the next 5 years litigating something, and by the way, you're not going to get anything when you're done. They're better off taking a settlement early on in that situation, because there's so much unknown. And that's been our experience. We have tens of thousands of clients all over the country. We just don't see a lot of lawsuits. But when they have surfaced, we had a $30+ million claim settled for 1.5, and the client was dead to rights, right? But he did have protection in place, and they're willing to forego all the, trying to crush and, maim and trial. And they said, at a fair settlement, to not have to do that is X. And the client was able to do that and get on with their life. Doesn't mean that you tell people to, fly it up a flagpole, pound sand or whatever. You actually pay your obligations. But what it does is it keeps the frivolous stuff away. Frivolous suits they're not going to have, because it's not worth it for them. They're not going to sue you just for the sake of suing you and doing harassment, because there's nothing to take, that you're just going to tell them to go away. And they're not going to take that case to the mat in those circumstances. But if there is a case that's legitimate, you signed on the bottom line on something, 2008, 9, and 10, you saw people left with huge liabilities on land projects and real estate projects. What it does is it gives you something to negotiate with, so that it's not a complete loss. And that's ultimately what it's about. It's about mitigating your risk. What's the worst thing that can happen, and making sure that doesn't happen. And that's all it is.
Okay. So Wyoming LLC for the trustee, and then beneficiary LLC would be registered in whatever state the property is located in. And then you said there's separate LLCs for each property. So would
And
you set
then
up separate trust, or would you use that same Wyoming LLC as a trustee for different trust?
you could use the same Wyoming LLC as long as it doesn't own anything, we'll use it as a trustee on as many trusts. Like we'll just pop it in there, or we'll set up different ones if you're worried about having too many. Generally speaking, you don't have to have a land trust if you're buying cash in certain jurisdictions, right? We're going to use a land trust if you have a mortgage in Florida, for example, because they have a dock stamp fee on transfers into an LLC that has debt, but not the same thing on a land trust. So if you have debt, you're always going to use a land trust first. If you don't have debt, you could put it straight into an LLC. That LLC will likely be owned by a Wyoming LLC. So there'll be a single holding Wyoming LLC that you own. Generally, if you're a spouse, you're going to do a partnership return. There's a reason we do that too. We want a partnership return because for Freddie and Fannie, they use 100% of your income ratio when it's on page 2 of a Schedule E versus if it's on page 1, they'll only use 75%. So if you are levering up, you're going to want to have a partnership return. If you're not, you might make it disregarded. If you're not using debt at all and you're just buying for cash, you might just have an LLC for property held by a holding LLC that you and your spouse own. And that's all she wrote. That's your entire structure. It's almost impenetrable. It's not super costly to operate. And there's not even a tax return under that circumstance. It's just going to flow onto your return. Actually, very, very simple, super effective. Very, very simple, keeps your name out of the public record too. So if anybody ever goes and says, who owns these properties? They see an LLC. Well, who owns that LLC? There's a good chance they're going to have no idea.
Okay. And yeah, that brings me to one other question, because my mind always wants to poke holes in things and say, really, is that, because it sounds really good, and it sells really well, and it's, this nice romantic idea. Maybe there's something wrong, but so I was just Googling around. I saw the Wyoming Limited Liability Company Act, section 1729 210B. It just says, except for articles of organization, any document filed with Secretary of State shall be signed by a member, manager, or other authorized individual. But that's the question is, well, does anything else need to be filed with the Secretary of State for Wyoming?
That's it. Like in our firm, we sign off as the authorized individual. So like if I go to look at your LLC, I can't go Google Mason Clement and say, aha, there it is. They won't see anything. If somebody finds out, hey, you own ABC LLC, and they go to look at it, they're not going to see your name on it. They're going to see Anderson. They're going to see our firm, and that's what they see.
Okay, got it. And last question on the trust deal. So say you're like me and it's like, oh shit, maybe I really messed up and I should start using trust again, but set up in the proper way this time, now that I better understand how to structure them. Would it be prudent to like transfer all my cash to a bank account owned by this newly created trust? So that way, if there's ever any claims against that single LLC I've used for all of my deals, there's no assets in that LLC to attack.
Yeah, you wouldn't normally, people aren't setting up bank accounts for the trust. The trusts are just there to hold title, and the beneficiary is the one that has the right to collect rents, which is usually another LLC owned by a parent, right? So you could either have, if you're using a property manager, for example, they may just send the funds directly to the Wyoming entity. They collect it from the tenant and they go through. So there's nothing there. In your situation where there's been exposure in an entity, our recommendation would be to not have a bunch of assets in that entity. And I would probably place it in an LLC that's a personally held LLC for the purpose of holding my liquid assets. I might have my stocks in there, cash, savings account, whatever. And the reason, again, is because they can't take it away from you. Let's say that I put $1 million sitting in an LLC. You had a liability occurrence and they imploded your LLC that you were doing this in Texas, and they pierced it. And they come after you. Again, the only thing that they could get against the LLC that's holding the cash is a lien. You still have settlement because you're going to say, hey, I'm never going to distribute the money to you. You can lien me all day long. You're not going to get the asset. Your lawyer's going to say, what will you take instead? And again, chances are it's going to be long before you ever had your piercing done on your, like you're going to be in a They're going to be saying, what's the best case scenario? And you're going to be saying, what's the worst case scenario? And you're going to meet somewhere in between and settle this thing out. So I could tell you, I've been doing this for 25 years, tens of thousands of clients, lots of litigation, lots of cases. Nothing ever goes to trial unless it's in an individual's name. And I could say that straight face because it's true. Where you see people get drug all the way to the end, where they go through supplemental proceedings, is when there's nothing there to stop those lawyers from doing it. And they'll just grind you into muck, and they'll take on crappy claims that should never have been brought. Nowadays, they always say, well, the court can impose sanctions. Yeah, it doesn't happen, not in the jurisdictions that I've ever seen. What happens is you have free access to the courts. So you got some billboard lawyer that's going to take 40% of the claim, sometimes 50% if they file litigation. And all they're looking for is the payday. And if you tell them, hey, you could have $25,000 now, or you can have zero later, they're going to take the $25,000 now. And that's what happens. They settle these things out because they're not going to sit there and grind. And we've seen people get judgments against folks that have these types of structures that we didn't set up, but they come to us saying, how do I get the money out of it? And you're like, well, it's really, really difficult. If they have a properly drafted plan, there's a good chance you'll never see a dollar out of it. You can keep renewing your judgment. You could say, hey, if they distribute out of it, if they have good counsel, they're not going to do any of that. They're just going to sit still and they're going to wait for you to lose patience. And eventually you'll be like, all right, how do we resolve this to where I get something? We've seen cases where people they should never have gotten the charging order in the first place. They spend hundreds of thousands of dollars getting something that they can't get anything out of, and they can't see what the people own. And they get really, really frustrated. And you're like, yeah, you probably should have settled that one early or not taken it.
Okay, interesting. I guess last question on that, just to rewind, in terms of like just the range, because I've had where the title company says, oh, we can't pay the beneficiaries. It's got to be, the check's made out to the trustee. This is like super technical nuance of it. And this is like why, back to the beginning of the episode where I said I created my own administrative nightmare, I was creating a separate EIN for each of the trusts, which implies I need to file separate tax returns. And I had separate bank accounts for each trust, and I was doing each transaction in each trust. And I was also doing this for like separate series before I started using trust, and just all a mess. And actually, I still need to send a letter to the IRS saying these 20 or 50 or whatever it was EINs have created an error and should be disregarded entities and all this stuff. But I'm still thinking, how do you get the funds? Say you're not even renting it, it's just a flip, but you're doing it through this trust structure. And the title company says they need to write that check in the name of the trustee. So you still need some type of bank account. How does that work? Because to set up the bank account, my bank required an EIN. That's why I was setting those up every time.
You could
EIN and entity docs.
Yeah, you could set up a grantor trust EIN. You could set it up as a revocable trust. You could, and open up a bank account if you had to, or if it's to the trustee opens up the bank account and accepts the funds. So it depends on who's issuing the check. You could change the trustee. You could change it to you. You could have the LLC on paper, because this is not something that goes. It's not filed with the Secretary of State. Have them revoke and give it to you, or to the beneficiary to select you as the trustee, so you can take the funds. So there's plenty of ways to work around. Worst case scenario, they say, you know what, Mason, we want to send it to the LLC that was on the title on this date. Okay, set up a bank account for it. Or if they say, you set up an EIN, so we want the bank to, or we want the land trust to actually open up a bank account. Yeah, it's a pain, but go open up the bank account, get the check, negotiate it, distribute it to the beneficiary, and be done with it. Like, yeah, that I have seen that happen over the years. It's seldom, but it does happen. And the other thing people try to do is they'll go try to do a refi in the trust. You got to take it out of the trust, put it in your name to do a refi, and then put it back in the trust. Most banks are going to do that with a living trust too, if it was individual. But under those circumstances, you're dealing with a lender. Do what the lender says. There are lenders that will do the loan in the land trust, but most traditional lenders that don't do real estate investing, they're going to say, oh, it's a grantor trust. It's nothing more than a living trust. We don't finance the living trust because you could change that beneficiary tomorrow. We'd have no idea. So we're going to loan it to Mason. And then Mason, you can go ahead and put it back into the trust once we're done. But we're going to do that loan and we're going to make sure it's with you.
Would that open me up to any exposures and my name suddenly in this chain of title?
Your name would definitely be in chain of title, and there would also be a mortgage on the property. Okay. So is it massive? No. But that's the trade-off of getting a loan. If you're doing cash, never have to worry about it. But if you're doing financing, they're going to make you put your name back on it. Same way they're going to do your house. And then you put it back into your living trust the same way. Land trust, living trust, same type of trust. They're grantor trusts that are revocable. One holds title, one is there to hold all your personal assets and to cover in case you become incapacitated. And then once you're passed, distribute your assets. Land trust is just there to hold the land, and the beneficiary is the party that has the right to occupy the premises and to collect rents and things like that.
Okay. Got it. Yeah, there's one other question that I was going to ask as a follow-up to that, but it slipped my mind. But that's fine. Maybe it'll come back to me. But changing gears here, I know we're kind of coming up on time here, but there was a couple other things. Like I watched your video on cost segregation analysis, which I learned you cannot do on your primary residence, it appears. No. So, but only investment properties. But I was wondering if, say my CPA had straight line depreciated it because he didn't know any better for my two rent houses for the past few years, but then I wanted to do a cost segregation analysis going forward because I think I'm going to get more depreciation. Is that possible to switch?
Yes.
For like the non-depreciated portion? Is that how it works?
Yeah, it's a change of accounting. It's Form 3115. And what you're actually doing is you're going from an impermissible method to the permissible method, which is to treat asset classes under their appropriate lives. When an accountant does a straight line on a residential property, they're actually doing the impermissible method. But the IRS doesn't care because you're paying them more, so they let you do it. So whenever you hear about somebody doing 27.5 years on property or 39 years if it's non-residential property, they're doing it wrong. You're allowed to do it, just know what it is. And you could go to the correct way anytime. And the rule is going to be the year that you put it into service as an investment property. That's the year that we'll have the eligibility for something called bonus depreciation. So you could change in English, just so I don't lose your listeners. Let's say that you walk up to a piece of residential property, a beautiful single family rental property that we see on TV. You know, they do the flip this house thing, right? And here's the crappy property. We fix it up and we make it a nice property. But instead of selling it, you're going to keep it and you're going to rent it. When you walk up and you see the brand new shrubbery they put in the front yard, and they put a new driveway, a nice walkway up to the front door. You walk in, they replaced the carpeting, they replaced all the cabinets and the appliances. You go out and there's a brand new deck, and then there's a bunch of trees that they put in, or some sod. They put in new grass in the backyard, all that stuff. So when an accountant walks up and looks at that, or when the IRS walks up, they're going to say, hey, that driveway looks like it's 15-year land improvement. Hey, the walkway is 15-year land improvement. Hey, those trees are 15-year improvement. Hey, the carpet is 5-year property. Hey, those appliances look like they're 5 or 7, or there's cabinets 5 or 7, or you look in the backyard and that deck is 15-year. And I look at the trees and those are 15-year. Like, I'm breaking it down into the useful life of each item. That's technically what you're supposed to do. And that's what a cost seg is. It breaks it into its useful life. So let's say you had a property for 3 years. And in that 3rd year, you had a moment of clarity and you said, let's cost seg this property so I can write it off faster because I have passive income that I want to offset so I don't have to pay so much tax. Or I'm a real estate professional and I don't want to pay tax on my W-2, so I'm going to accelerate my depreciation and not have to pay tax this year. You go in there and you look at it, you break it down. I could do that in year 3. And then I just treat all the property as 5, 7, and 15-year property as though that's what it was from the get-go, because that's actually what it was from the get-go. So I'm in year 3. and I've got 5-year property, it means anything that I didn't write off in those first 2 years, I'm taking it all now. I'm going to have a whole bunch of depreciation in those last couple of years because I'm at 5-year property. 7-year, same thing. 15-year, same thing. I'm going to be writing it off much faster. And in those first 2 years, the amount that I missed, I take in year 3. So I'm going to get a big deduction in year 3, pretty good sized deduction in 4, pretty good sized in 5, and then it's going to start going down as we go along. So if you want to bonus that, it's the year that you put it into service. So this was 3 years ago. So let's say you put it into service in 2020. That's a year where we had 100% bonus depreciation. So anything that's 20 years or less, you can write off in the year that you make that election. So all of your 5-year property, all of your 7-year property, all of your 15-year property, you write it all off if you want in the 3rd year. You could just, hey, we're 3 years in. I'm going to make a change of accounting for 2022. That's actually 2 years in, but let's just say whatever. We're going to take this big, huge deduction and we're going to do it right now, or maybe make it for 2023. So you say, hey, this year is going to be the year. I'm not going to make my change of accounting election for 2022, even though you could up until you file your tax return plus extensions, but I'm only going to do it for 2023. You do that, you're going to have a huge write-off in 2023, right? Even though you bought the property a few years ago.
Okay, I heard that the Trump tax laws were kind of being phased out. So how does that play as well? 'Cause people are saying 2020 is the last year you can recognize 100% depreciation that goes like 80 and 60. Can you explain that a little bit?
Right. So for cost segregation, it does nothing to the cost seg analysis. What it does is whether you have bonus depreciation. 2022 is 100% bonus depreciation. 23 is 80%. 24 is 60%. 25 is 40%. And then I think it goes away in 2026. It phases out. There's a phase out taking place. Whether we get there is up to Congress, right? Because it used to be just 50% bonus, and then sometimes they'd have it, sometimes they wouldn't. Excuse me. But that's only on, do I accelerate the depreciation on that 5, 7, and 15-year property? You could still cost seg a property and write it off faster. It's just, if I have a carpet and it's worth $15,000, do I write it off at, whatever that is, $3,000 a year, or do I write it off $15,000 in year 1? So now it's 80%. So if you have $15,000 of carpet, you take 80% of that I write off in year 1, and then the rest of it you'd take over 5 years.
Okay. I actually had heard differing things from multifamily investors, where one had said there could actually be disadvantages to accelerating all that depreciation, and then other people say, no, it's a great thing. So what is your view on it?
I think you run facts and circumstances on any time you're thinking about doing it. You do an analysis. So where an accountant might say it could be bad is if you're selling a property that you've had for 3 years and you accelerate depreciation on personal property that has a lot of value left, it could be treated as ordinary income, taxable at your ordinary rate. So it depends on what your ordinary rate is as to what the tax consequences would be, as opposed to, hey, if it has no useful value, if I've had it for 3 years and a good chunk of it's been used up, then I have 0 recapture. And that's what you're balancing against. So you're saying, based off of my facts and circumstances, do I better my position or worsen my position by doing a cost seg? You don't know until you run the numbers. So I'll give you an example. Somebody had that same accountant who said, don't do it. You're going to have to all the recapture is going to destroy you. It's going to be higher tax. So they didn't. They sold the property. Then they listened to a webinar. They went and they listened to one of ours. So I said, get the analysis done. Well, they sold the property already. That doesn't matter. You can still make an election up until you file your tax return plus extension. So they said, well, it's too late. And our guys, we actually refer off to a group that only does cost seg. They're a bunch of accountants. All they do is cost seg. And and credits, the 45L and the 179D and all the different types of tax credits. And they said, let's run the numbers. As long as we can get an engineer in there to do a study, we could see. Well, long story short is it saved the client $78,000 in taxes, not $78,000 extra deduction. It was a warehouse that they had purchased, and they held it for, I want to say, they bought it in 2015, sold it, I want to say in 2019 or 2020. Actually, I think it was 2018, and they came in 2019 and did the analysis. The tax savings to their bottom line was $78,000. The cost of the study was probably $10,000. So their net benefit was $68,000. So the accountant that's just free advice, oh, it's never works. Oh, don't listen to that. Just do your own homework. I used to joke that there's 3 rules to tax: calculate, calculate, calculate. Get your pencil out and see whether it actually helps or hurts you. A good company is going to do that analysis, and they probably won't charge you for it. So it's not rocket science. It's fairly straightforward. Usually you can tell, hey, if I do a cost seg study, for example, I want to know going in how much it's going to save me. Well, I need to know what my tax rate is. I need to know if I'm a real estate professional. I need to know if I'm an active participant in real estate. I need to know if I'm just all passive. Do I have a whole bunch of syndications that are kicking off a bunch of passive income? I need to know these things. Is it ordinary income at 37%, or is it hitting me at 12%? Right? That's what you actually have to figure out, because it's a same cost seg, same property could have 2 very different outcomes for you or me, right? And the only way they're going to know is if they run that scenario. And then they could say, hey, Toby, for you, a cost seg would save you $23,000, and it's going to cost you $2,000. They look at you and say, hey, Mason, for you, the cost seg, it's going to save you $3,000, or maybe it's going to save you $30,000. It's going to even be more beneficial, and it's going to still be the $2,000. You may be like, Toby, we need to do this, right? The only way we know is if you actually run the numbers.
Okay, that's definitely helpful. And it actually is a good segue. What I've learned is that the real estate professional status, because we weren't able to, use all of that depreciation, the straight line depreciation my CPA calculated to offset as much as we wanted to, because it was considered passive and you can't offset that against your wage, W-2 income. But this year will be the first year where I am, or for 2022 tax year, where I should be able to be a real estate professional pretty easily. So I was just actually curious, is it possible, say, since I am a real estate professional and could recognize more of the depreciation, could that possibly be so much that it also offsets my wife's W-2 income, since we're doing like married filing jointly?
Yeah, the answer is absolutely it could. That's why people do it. What it does is, for the tax return, it makes passive losses from rental real estate into ordinary loss because you're a real estate professional. And the test is under 469C7, and it's not magic. It's, does one spouse on a joint return make their living, more than half of their living, more than 750 hours in a real estate trade or business? And in order to qualify, you have to own at least 5% of that trade or business. So that's test number 1. So do you do something that's in the real estate trade or business? Okay, one spouse qualifies. Then they say, are you guys materially participating in the real estate in which you invest? And there's 7 tests that you could qualify under. The easiest one is, hey, you self-manage everything, and you do substantially all the activities. If that's the case, there's not even an hour requirement. You just automatically qualify. Otherwise, you're going to have to do at least 100 hours and more than anybody else, or they're going to add up your time between you and your spouse, and it's going to need to be 500 hours or more of management activity on your real estate. Investment activity, no. It's just, are you managing your rental real estate? And usually you need to make an aggregation election. I've never met somebody who could do it just on one property. You make an aggregation election for all of your real estate, rental real estate, and they treat it as one big old activity. So your hours on one property affect the entire group. And that way you can have syndications, things that you're passive in. But if I'm active enough in 3 properties and I pass that threshold, I'm a real estate professional. I'm no longer passive. I get ordinary loss, and I could use it against my spouse's W-2 income, against any type of income that's out there.
Okay. But say we got those 2 rental properties and property managers are handling those, but I did like 30 other transactions with just some land flips. So those 30 other transactions that'll allow me to qualify as a real estate professional, correct?
It's going to get you past test 1, which is 750 hours, more than 50% of your time. So what they care about is, what are you doing for a living? And do you like, if somebody has no other job and they're doing real estate more than 750 hours, like what you're doing, what you're describing to me as a flipper, that's not an investor activity. That's a trader business activity. You're a dealer in real estate. So when you're flipping land, I would consider that a real estate trader business. So did you do more than 750 hours? Yes. Okay. We've stepped past prong 1. You are now a real estate professional. And then the question is, did you materially participate on your real estate to make it non-passive? If you did, so they look at you and your wife and you say, did you guys hit one of the tests? And there's 7 tests, but the 3 that we care about are, you said you had another property manager. So test number 1's out because somebody else is managing the properties. Test number 2 is, did you do at least 100 hours between you guys? And did anybody on your property management team spend more time? So if your property manager has a team of 5 people and they spent a total of 30 hours on your properties, you don't have anything to worry about. You got to make sure you did 100 hours of managing your property. So you got to, I'm there working on fixing things. I'm handling tenant issues. I'm dealing with the manager. I'm dealing with contractors. I'm doing all this stuff. Does that add up to 100 hours? And am I the most? Yourself and your spouse combined? Are you more than anybody else? If the answer to that is yes, you now qualify as a real estate professional. It's no longer passive. It's now considered ordinary loss. You're good as gold. If the answer is no, it's still passive.
Okay. Got it. Yeah, I may have to revisit that then, because although I'm like full-time doing this real estate trader business, it may not qualify as a real estate professional simply because 750 hours.
That's the hard part. You gotta, there's 2 tests. The second test is in the revenue rulings. It's not revenue ruling. It's in the revenue procedures, RevProcs. It's in the interpretation of the law. So when you look at the statute, it's not really going to help you because it's silent. It doesn't say, oh, you have to do this. What they did is they said, hey, in order for you to be a real estate professional, once you're a real estate professional, because here's the reality. Just because I'm in a trader business does not mean I materially participate. Like if you and I open up a pizza shop, you could be flipping all the pizzas. I own half. I work 10 hours. I'm not a material participant. It's passive. So if that thing kicked down loss, it's passive loss to me because I did not materially participate. So it's up to the individual to meet the material participation test. That's the test that people screw up on. And every time you see the court cases, somebody says, but I'm a real estate agent. I'm a real estate professional. And the court says, you meet the first test, but you don't materially participate on your real estate. And they said, but I spent 2,000 hours doing real estate. You sure did. But your rental properties are presumed passive unless you meet these 2 tests.
Okay.
There is a second one, Mason, real quick. If you're making less than $150,000 a year, you could qualify for something called active participation. So if somebody's making $100,000 a year, you can get a $25,000 loss from your passive real estate and treat it as ordinary loss. So there is a second one that's easier to meet that a lot of people ignore because they assume everybody's rich that's doing real estate. But if you're, if you're good with your deductions and you have your own business and you're making, husband and wife are making, $100,000 a year, you could probably take up to $25,000 passive passive loss and treat it as ordinary.
Okay. One also side question to that, say we had like a third property we were participating in, and we qualify as a real estate professional for that property, would we also have to separately qualify for the other two properties that are handled by the property manager?
If you aggregate them, the answer is no, you don't have to do it for each one. So you aggregate your rental activities as one activity. Like here's the reality. So let's say that I buy let's say it's you, and you buy a piece of real estate and you run your business out of it. And let's say your business is a mini mart, and the mini mart makes money, but you have this huge loss from the real estate. You can treat that as one activity. It's called a grouping election. And I can group the active trader business with the real estate because they're related. I'm self-renting. And I could use the passive losses and offset my active income from the other activity. They actually offset each other, treat it as one. Some people don't realize that you can do that. So they self-rent to, like, let's say it's doctors, and they have an S corp for their practice. And they have this big surgical center that they self-rent. They could absolutely take the depreciation from the surgical center and offset their other, their practice income if they're self-renting. So that's called grouping. Otherwise, you aggregate all your rental activities as one activity and treat it as just one activity. So if you have 3 syndications and 2 properties that you manage, the syndications I don't do anything on. The 2 properties I self-manage are rental properties, and I meet the requirements to be a real estate professional, and I'm materially participating. And I aggregate the 5 properties together, 3 syndications, 2 that I'm actually managing. So it's 5 altogether. I treat them as one activity. Now there's no longer 5 separate activities. It's one. Did you materially participate? Yes. Great. All of the loss is now non-passive. It's no longer passive loss. It's ordinary loss that's going to offset my other income.
Huh. Okay. How do you prove that 100 hours for that threshold that I spent over 100 hours?
So it's up to you. You track it yourself. The IRS says whether it's creditworthy or not. So like the cases where they've disapproved is when somebody left the country and said they were still doing work on their properties. And they said, there's no way in hell you're doing any sorts of management activities on that property. Unless you could prove that you were working with tenants or things like that, then no dice. They weren't going to get it. But there's been people that didn't even keep contemporaneous records, and the court found them credible when they gave testimony about their time, and they said that's okay. So if there was a case where a guy, he self-managed his unit. Actually, I think he only had 1 unit. It was an old guy, and he just always went over and tinkered around on those properties every day. And everybody said, hey, we see the guy tinkering every day. He comes over, says hi to the tenants and fixes stuff, and he's working on something. And he said, hey, I did it every day, just about every day, every weekdays. And the court said, yeah, you probably did over 750 hours. So he met the active participation because management activities it counts, and you materially participated on your property. Yeah. And they gave it to him.
Okay. Yeah, that's very interesting. But otherwise, I've heard other stories like that too, where you get the audit, and then as they start hashing through the records and the timesheets, it's like, it's kind of bullshit. It's not going to work.
Use one of these. Track your time, who you met with, what you were there for, what you were doing. They did. I've seen them deny people because they said there's just no way. They were driving to the out-of-town condo like every weekend, and they were trying to count their time. And then they would say, what did you do when you got there? I mean, they went to the beach, right? But they're like, oh no, we were fixing the place. And the court just said, you're full of crap, right? We don't let you count the time that you're commuting, or that we don't find anything you said credible. They throw it out. So you got to be kind of a knucklehead to try that if you don't have any backup. You have the Home Depot receipts. You have somebody's testimony. Yep, I worked with this person and we were fixing this up. Every weekend we'd go and we'd work on the condo. You have that, you're going to be okay. You go there and you say, yeah, I worked on the place. Well, what did you do? Where's the receipts for the paint? Where's the receipt for any of the materials? You don't have that, you're done. And you just made yourself very unlikable to the court. They're going to be pissed off. And that's what they do. They just crunch it. When they like you, and there's a gal, another one that she qualified, she didn't have good records, but they found her testimony credible, is the one who actually could show, hey, here's some credit card receipts. Here's when I was there. This is what I bought. Okay, that backs it up. Otherwise, keep contemporaneous records and you're fine. It shifts the burden to the IRS. And then they'd have to disprove it. So if you keep good records, you win. You have crappy records or you lie, you lose. Right? So like it's not that hard.
Right. A second ago, you tapped on your cell phone, use this, but what do you mean exactly for that? Is it like tracking mileage on the QuickBooks app?
Miles, use Mile IQ, use your calendar, just go in there and say, this is what I did on this date. Hey, on this, and it's just keep a log. It's contemporaneous, or use notes, or do a voice. Hey, I'm here at the property. This is what we're doing today. Anything to show that it's not just your testimony. Yeah, I fixed the place up. They're not going to believe you. I went to the condo that I was using as an Airbnb 20 times, and I should get to count all that time that I spent there because I was fixing the place. You better have some pictures. You better have some receipts and materials. You better have somebody saying this is what we're doing, before and after pictures, stuff like that.
Well, this morning, I took pictures and video of a piece of land that we're developing, but that's probably not going to qualify because we're not renting that out, right?
No, in land is not depreciable. So what you can do, but here's the beautiful part, Mason. If you're doing land improvements, so you're putting in infrastructure, you know, when I say like you do a mobile home park and you're putting in the pad and everything, that's 15-year property, 100% deductible in year one in 2022, 80% deductible in year one in 2023. So, you know, you develop a property, you buy it for $500,000, put $400,000 of development in it, you're going to get it pretty close to a $400,000 deduction in year one.
Okay, interesting. Yeah, I might definitely apply on other projects I'm working on, possibly installing like a $500,000 road.
And did I mention there's a lot of bad information in this space? Like, you're probably hearing some of this for the first time from somebody who's actually qualified to talk about it, who actually does it. And unfortunately, there's a lot of gurus out there who don't know anything about it, telling you to do stuff that's not the law, and it doesn't make any sense, and there's no backup for it. But because they have a platform, they can espouse and say crappy things. It's not rocket science, but it's also pretty black and white. This is what the rules are. This is how you qualify for it.
Yeah, exactly. But for those times where it's like, oh, well, maybe people don't qualify, but it sells really well if I say that people do, and so it's just kind of glaze over that, right? Skim over it.
If you have a full-time job, don't try it. But there is one area that people don't realize that you can do. So rental is considered passive, but the question is, what's a rental activity? Airbnb, for the most part, is not a rental activity. It's actually a trader business. So it's like anything else. You're going out there and you start up you're going to be a real estate agent. It's no different than that. It's just trader business income. And if there's losses, it's ordinary loss, so long as you materially participated. You're going to hear that word all the time whenever you're dealing with passive loss and converting it over to ordinary losses. Did you materially participate in the activity? Were you a silent owner in a pizza shop? Well, I don't know. Did you flip pizzas? Yes. How often? Every weekend. Okay, so you did 50 weekends and you worked how long? 2 shifts, 8 hours each. Okay, so that's 16 hours a weekend times 50. Yeah, you materially participated. Okay, so it's non-passive. That's what an accountant's going to do. And you know, and what's funny is those folks that are out there doing Airbnb and they're trying to cram it through the real estate professional hole. They don't have to. You're like, time out. It's its own activity. It's a trader business. It's not part of your rentals, but I'm renting it to people. It's not considered, it's a hotel. It's not a rental. 7 days or less. That's the rule. It's not a rental activity. It's not passive. It's no longer presumed to be passive. It's just a trader business. And the only question is, did I materially participate on my Airbnbs? If the answer is yes, it could be a surgeon who in his spare time buys a condo, puts it into service in July, and for the next 2 or 3 months rents it out and likes to go over there and clean it and do everything, and nobody else did anything with it. They're going to get a massive deduction in year one because they could cost seg it, take the accelerated depreciation and use it against their surgeon income. Some of these guys are actually doing that, especially husband and wives, or they're with spouses, and they're like, hey, this is going to save us $100,000 this year if we could buy this condo in our beach community and make it into an Airbnb, and we're just going to do it for 1 year. We're just going to work our ass off for 2 months and we're going to qualify. Yes. And then we're going to write it off. Fantastic. And then make it into a rental property, then rent it long. You don't have to worry about it. I could do that for 1 year. That loss is not a passive loss. Every year you determine whether something's passive or not passive. So you can end up with a big tax deduction. So Airbnb is one of those little secret sauces. If somebody has a tax appetite, it's not like other rentals. It's actually considered a trader business. It can offset your W-2 income or other income.
Okay, what about like a self-storage facility that I manage myself?
If you're self-managing it, then a self-storage is almost always going to be a rental activity because you're going to have month-to-month rents. These are not 7 days or less, unless it's a weird storage where it's like, hey, I'm putting my scuba gear here for 3 days, but most of them are going to be long-term. So that's rental. But same thing. If I meet the 750 hours, let's say I self-manage it. So I hit 750 hours doing real estate trades or businesses. I add them all up and I do that. And then did I materially participate on that property? If I self-managed it and nobody else did substantial activities, I automatically qualify. Now I could take a mass, because self-storage is huge amounts of depreciation, because most of that stuff is not structural. Most of that improvement's going to be 15-year land improvement. So you're going to get a huge deduction in year one. And then that could wipe out a lot of your other income.
As long as I materially participate doing over 100 hours throughout the year.
It's doing substantially all activities. Nobody else provides substantial activity. It's 100 hours or more, and nobody spent more time. So if I spent 150 hours, the next guy spent 125 hours, I'm good. Or it's 500 hours. So and there's other ones too. There's 7, but those are the 3 that are really the ones that we see reoccurring over and over again.
Okay. So I could spend time hiring a contractor to fix one of the rolling doors or do other stuff, but as long as I'm spending more time hiring contractors than they're spending on fixing them.
100% misunderstood horribly in the accounting world, and lawyers are even worse. Is they don't, again, it's hard for them to get this. They want to say 750 hours. That's only one piece of the test. And that's only the test as to whether you're involved in a real estate trader business. And if you go back to 1986, when the passive rules came out, 86, it was basically for everybody. And then the construction folks and people that did real estate said this is unfair to us. Like before 1986, a doctor could just invest passively and take massive deductions and offset their income. So Congress said, not anymore. We're not going to do tax shelters, is what they called them. And so and then the people that were actually in real estate, like developers and construction, said, hey, this is unfair to us. And so they came out with C7, which basically said, all right, here's the exception for real estate professionals. You're an owner in a business that does development, redevelopment, construction, reconstruction, management, rental. If you're managing rentals, if you're involved in the brokering of real estate, if you're involved in those activities, and it's more than half your time and more than 750 hours, you're a real estate professional. And if that's you, then you have the ability to materially participate on your rental losses and make them into ordinary loss.
Okay. Very interesting. It's great stuff. Last question, just to wrap it up. I had paid some other mentor guru thousands of dollars who had said that he had set up this nice fancy structure that included gifting. At the time, the tax limit for a gift was like $10,000 to your child, and that was deductible to lower your income. But it seems like it's only for charitable organizations.
Yeah, gifting is not a deduction. Gifting is a non-taxable to the recipient. It could be taxable to the giftor unless you fall under one of the exclusions. And the annual exclusion, like this year, is 17,000. It was 16 last year, 15 the year before. And so it was probably some time ago, but you don't get a deduction for it. They just don't have to pay tax. You don't have to pay tax for giving it to them. You also have, I think it's a 12.9. I mean, it's a huge, so an over $12 million lifetime gifting amount that I can give. It mirrors your estate tax exclusion, but I have to file a Form 706 to claim it. So that's just to keep it from being taxable, not deduction. If I give my kids money every year, I don't get a deduction for that. I just don't have to pay tax, and I'm transferring the money to them. So if you want to give your kids money that they don't have to pay tax on, pay them from your real estate, pay them to sweep, pay them to do any activity. And if it's less than, I think this year it's 13,000, the standard deduction is a little above 13,000, then they have no requirement to file a tax return. So you could pay your kids up to a certain dollar amount as long as it's active income. If you're doing it through like your real estate partnership or through your return for your real estate, not through a corporation, then you don't even have withholding. You don't have any employment taxes. There's a family exception. And they could take, what is it now, 6,500 of that and put it into a Roth IRA and never pay tax again on that money. So if you want to get real medieval on it, you say, hey, great, they don't have to file a tax return, plus I could get it into their Roth. And if the kid is, I think it's over 12, you could have a custodial Roth account. But if they're 16, 17, 18, then they can open up their own account.
Okay, got it. Yeah, maybe I misunderstood the guru or what he was trying to get at. So cool, that's helpful.
You probably understood him, Mason, and they probably just didn't know about what they were talking about. A lot of those folks are out there talking tax stuff that is garbage. And you look at them and go, gosh darn it, you should have to practice in this area for a little while, because the harm that you do by them planting those seeds is pretty egregious. And they may be doing it well intentioned. Usually it's to, they're just selling something. But for the most part, you're just looking at it going like, here's what the rules are. Here's where the benefit is. Here's a great thing you can do. It's pretty finite. There's about 10 things that, you could, that make a lot of sense for most people. HSAs make a lot of sense. IRAs make a lot of sense. 401ks make a lot of sense. Accelerating depreciation, if you have high income, makes a lot of sense. There's things like that, paying your kids instead of you paying for expenses for them, because now I don't have to pay tax on making that money. That makes sense, right? Gifting money to the kids doesn't make a lot of sense. I don't get a deduction for it, and now the money is no longer mine and I have no control over it, and they may do stupid things with it. So we probably want to be careful about what we give our kids, right? If you want to pay them and then have them pay for their schooling or pay for their expenses, that's great. You get a deduction and they don't have to pay tax on it. That's smart. Or you get it into a Roth account. That's great. But yeah, you don't want to just gift, just willy-nilly gifting to kids is probably not a smart idea.
Okay, great. So last question, I actually spoken with your firm about like working with y'all to do my tax returns. I think that y'all are some of the most strategic, and actually I was referred by a land investor friend who y'all had done it for, but it was kind of confusing on how to work with y'all because I already had some entities set up. You'll have to set up entities first to be able to do the tax returns. Could you just explain that? Because maybe I do need to set up new entities anyway, and I could work with y'all still, but let's go into that a little bit.
At our firm, we don't just do taxes for anybody. We want you to be an asset protection client, and then you're eligible to be a tax client. So we don't just sell taxes. So if you're coming through our firm, be prepared to be looking at, we're going to look at you holistically. We don't want to just bits and pieces. We don't want to just be your RA. We don't just want to do a tax return. We don't want to just do books. If you're coming into our firm, it's hard for us to work through a lot of the crap that's out there. I mean, I don't want to put it in a bad way, but there's a lot of people doing a lot of bad things out there with the advice they're giving. And so we want to be able to look at the individual and say, all right, we're doing everything right from the get-go. We're not trying to fix anybody's problems. And these are the types of services. So we may restructure somebody, make sure that the documents are up to snuff, because we don't want you getting sued and losing your assets. We don't want to have a provision in an LLC that was set up on an online provider, or some lawyer doesn't know what he's doing. And now you have mandatory distributions that we don't know about. And then you find yourself in a lawsuit and now you're getting hung by it. And you're saying, gosh darn it, why didn't you guys tell me? And it's like, because we didn't set it up. So when we work with somebody, we're probably going to fix all the broken pieces. And then even then we have a long waiting list right now on tax. It's worthwhile getting on it, but we have about a 5-month waiting list to get in for the tax analysis and to really dive in. And the reason we do that is because it's time consuming. So it's like anything. Unfortunately, we're a little bit more in demand than the capacity at all times, but we do work through it and we work with people. And once we bring you in, we're going to give you the attention to try to make sure that we don't have snafus and you don't get yourself in a bad situation. So sometimes that's fixing things and sometimes that's proactively saying, here's how to go forward.
Okay. So if I wanted to work with y'all to restructure or start with a clean slate and do taxes for me or my business, since there's a 5-month wait, would it not be for 2022? It would need to be for 2023.
It would be 2023 for tax. You could start on the asset protection side right away. Like there's no wait on that. It's getting you into a tax. You are going to go through a tax analysis process and it's just time consuming. So I wish we could just say it's as easy as doing a return, but we're looking at your past returns. We're making sure that you're taking advantage of the deductions that you're entitled to, and we're coming up with a philosophy going forward. And unfortunately, that's more labor intensive than putting together an asset protection plan, which becomes fairly straightforward once we get to know you. So you walk through the asset protection door, and we'll walk you through the tax door, but there might be a wait on the tax door.
Okay, that's fine. Yeah, maybe I'll just follow up with the folks that I had initially spoken with and say, hey, I want to go on the asset protection thing. So I think maybe they misunderstood me, or I misunderstood myself on thinking I already had necessary entities set up and didn't need that service. So yeah.
Yeah, a lot of them do it with another attorney or something like that. And it's just difficult for us. The same way as if you came in and somebody says, hey, these are the people that I've been working on with land development. I want to do it the way that they said it. And you're going to be like, I don't know what that way is. There's 100 ways. I'd rather just start fresh, right? So that you're able to say, this is what works. And if you always have but I had another guy who told me this, and I had another guy who told me this, it's difficult, right? And so we just try to make sure that if they did learn it from somebody else, that's buttoned up. Because the worst, there's actually a really good case out of Salt Lake. I won't bore you with it. The guy got hung on one sentence missing out of an operating agreement. That's in every operating agreement we draft. And he had a big firm do his stuff. And it was one provision about a non-pro rata distribution and whether he was authorized to do it or not, cost him millions of dollars. And I don't want to be in that situation. I'm going to look at somebody. I want to make sure that we're doing it right and that we're not trying to read every line of an operating agreement. Let's just redo it the right way.
Okay. That's definitely mind blowing. So crazy. So if someone wants to work with your firm, how would they do that, or get in touch with you, or just move forward and learn more about Anderson Advisors? What's the best way?
Yeah, the best thing is to start learning. And so it's not just learning about us, but learning in general. So you have a good idea of the things to help yourself. You can go to my YouTube channel. It's simple. Just type Toby Mathis, YouTube. You could go to my partners, Clint Coons, Google, or YouTube, and you'll find him. Or you just go to our website at andersonadvisors.com. And we teach a class about every 2 weeks. We do a tax and asset protection class. And I would encourage you, if you're listening and you really want to know where to get started, that's where you want to because you're going to learn about land trusts, LLCs, corporations, the taxation of it, how to create a legacy. That's a free class. Just spend the time in there to learn. That way, when you're communicating with the professional, it's symbiotic relationship, right? You're communicating, you have a good idea what's going on, and nobody's just, at the end of the day, you got to know what's going on, because nobody's going to be doing it necessarily for you. Like, you're going to be running your business. You're not going to have a third party run it. You're going to be the one doing it. So you got to understand the pieces of it. So spend a little time educating yourself. It's not a huge amount. You can usually get it done. Spending a few hours really getting yourself familiar. This type of a podcast, for example, Mason, I don't even know how long we spent, but this is going to give somebody a lot of pieces that they wouldn't otherwise have heard. And it's pretty straightforward, but it's also irreplaceable. You got to kind of spend the time getting familiar with these terms so that someone doesn't lead you down the wrong path.
Yeah, definitely makes sense. And I really appreciate you taking the time to speak with me and add value to the show and our listeners. So thank you very much. I know it was enlightening for me, and I got my work cut out for me as well. Just to learn more. There's always more to learn on this subject of taxes and liability.
Absolutely. It was fun.
Good stuff. Well, maybe I'll be on another time as well. So thanks a lot, and I'll let you go for now.
You got it. Thanks, Mason.
All right, that's another episode of Scalable Real Estate Investing. Thank you for tuning in. Please be sure to leave a review and subscribe on whatever channel you're using to listen or watch these episodes. And also be sure to go to scalablerealestateinvesting.com, scroll to the bottom, and fill out the form to sign up for our email. And you could also reach me directly at mason@scalablerealestateinvesting.com. That's MASON at scalablerealestateinvesting.com. If you'd like to get in touch with me to either partner on deals or even be considered to do your own episode on this podcast. Thanks again, and have a great day.